Good morning, this is your Kelso Report for Tuesday, October 25th, and I'm your host, Clark Kelso. Well, we have a full slate of one-liners today, so we'll jump right in with administrative law and exhaustion of remedies. In RSD v. Holder, the Ninth Circuit held that the petitioner failed to exhaust his administrative remedies by failing specifically to challenge the immigration judge's ruling that he had committed a particularly serious crime, and therefore was subject to removal from the United States. Although the petitioner did appeal the judge's ruling to the Board of Immigration Appeals, the petitioner raised other issues in the appeal dealing with his alleged well-founded fear of persecution, and none of his appellate claims related to the judge's conclusion that by pointing a pump-action shotgun into the faces of two innocent people, he had committed a particularly serious crime. By failing to raise this issue with the board specifically, he failed to exhaust his administrative remedies with respect to that issue, and the courts then decided they had no jurisdiction to consider it. Accordingly, his petition for review as to that claim was dismissed. Next, an interesting double jeopardy question. In United States v. Revelis, the Ninth Circuit held that the Navy's use of its non-judicial punishment process to discipline the defendant for drunk driving was not a punishment that was criminal in nature, and that the defendant was therefore subject to subsequent prosecution by the United States for the same offense without violating double jeopardy. Under the Uniform Code of Military Justice, the maximum punishment that can be imposed in a non-judicial punishment proceeding is diminished rations, forfeiture of pay, reduction in pay grade, extra duties, restriction to limits, detention, admonition, a reprimand, and up to 30 days of correctional custody. The Ninth Circuit held that most of these types of punishment have been regarded as non-criminal in nature, and that taken together, they do not establish the clear proof necessary to convert what Congress intended to be a civil discipline remedy into a criminal penalty. And in the particular case before the court, there was no confinement. All of the rest of the punishments were imposed, but they did not impose any sort of 30-day confinement. Next, in the area of habeas corpus, in Doe v. Busby, the Ninth Circuit held that an inmate's counsel's extraordinary failure to file a habeas petition as directed by the inmate was sufficiently egregious to warrant tolling the running of the one-year habeas limitations period provided for by the Anti-Terrorism and Effective Death Penalty Act. This was not a case of mere attorney negligence. That wouldn't have been enough. Instead, it rose to the level of positive malfeasance and failing to fulfill basic duties of client representation. Reaching the merits, the court held the petition should be granted because instructions to the jury regarding prior unrelated acts of domestic violence permitted the jury to make findings about those acts pursuant to a preponderance of the evidence standard instead of a beyond reasonable doubt standard. We also have a state habeas case to consider. In In re Lucero, the 3rd District rejected a state habeas claim brought by an inmate convicted of 1 count of second-degree murder and 2 counts of attempted murder with special enhancements for firearm use. When the initial conviction was up on appeal in 1998, the 3rd District had rejected an argument that the jury was erroneously instructed on the felony murder rule in case where the predicate felony was willful shooting at an occupied vehicle, the same shooting that resulted in the murder. 10 years later, the California Supreme Court overruled its precedent in this area, holding that the crime of shooting at an occupied vehicle actually merges with the homicide, such that it can no longer provide a predicate for application of the felony murder rule. The 3rd District held that this new rule applied retroactively, but it still denied the habeas claim because when it reviewed the record, it discovered that, although the jury was given the felony murder instruction erroneously, neither the defense nor the prosecution had focused its attention at all upon felony murder. Instead, the case focused solely upon the application of imperfect self-defense. Thus, the 3rd District concluded any error was harmless beyond a reasonable doubt. Next, an interesting search and seizure case in Roby v. Superior Court. The 2nd District applied the California Supreme Court's 40-year-old decision in Guidi v. Superior Court to reject a plain smell exception to the warrant requirement. The defendant consigned a sealed package to a common carrier for shipment. Because the package reeked of marijuana, the carrier notified the police, who seized the package and then later opened it at the police station without seeking a warrant, even though no exigent circumstances existed at the time of the search. The court recognized that several federal cases have endorsed a plain smell doctrine analogous to the plain view doctrine, but citing auto equity sales, the Second District felt bound by the California Supreme Court's decision in Guidi that smell alone is not enough to dispense with the warrant requirement. Next, a criminal procedure case involving the district attorney's powers. In Gananian v. Wagstaff, the First District held that a district attorney retains his or her discretion to decide whether to investigate and prosecute alleged violations of laws related to the expenditure of voter-approved school bond funds. Section 15288 of the Education Code provides that, quote, upon receipt of allegations of waste or misuse of bond funds authorized in this chapter, appropriate law enforcement officials shall expeditiously pursue the investigation and prosecution of any violation of law associated with the expenditure of those funds, close quote. The court held that, particularly in light of separation of powers and the traditional role of district attorneys, this statutory language merely established a priority for these investigations if the district attorney decided to move forward, but it did not actually require the district attorney to investigate and prosecute simply based on an allegation. Next, we turn to the area of arbitration. In Sanchez v. Valencia Holding, the Second District struck down as unconscionable an arbitration clause in an automobile sales contract that contained multiple harsh, one-sided terms that favored the car dealer to the detriment of the buyer, including a class action waiver, a poison pill clause that if the class action waiver declared unenforceable, the entire arbitration clause would not be enforceable. The contract was presented to the buyer on a take-it-or-leave-it basis. The arbitration clause appeared on the back of the last page at the bottom with compressed line spacing that made it more difficult to read than the rest of the contract. There was no disclosure of the arbitration clause, and the buyer indicated he had no reason to suspect such a clause on the back of the contract. The court held it easily satisfied the requirements for being procedurally unconscionable. Substantively, the provisions contained a number of one-sided clauses, including a clause providing for appeal from the single arbitrator to a panel of 3 arbitrators if the award exceeds $100,000, an appeal if the award includes injunctive relief, a rule that the appealing party must pay filing fees in advance, and the provision exempting repossession from arbitration. Each one of these provisions favors the dealer at the consumer's expense, and the court held the provision substantively unconscionable. Now, as you know, the United States Supreme Court has been wary of California state courts' reluctance to enforce arbitration clauses. But I think this clause clearly went way too far, so I suspect the Second District's decision here is on solid ground and will withstand any review that it may receive. Finally, in the area of public pensions, in Molina v. CalPERS, the Second District held that a former employee of the city of Oxnard who received a substantial payment as part of a settlement of his wrongful termination action against the city was not entitled to have that payment included in the calculation of his retirement pension. The settlement agreement itself expressly provided that the proceeds constituted neither pay rate nor special compensation. And under applicable state law, such settlement proceeds may thus not be legally utilized to increase his pension benefits. And that's it for today's Kelso Report. Have a great day in the law.